our program today is the 13th annual UCI SCOTUS review. And Tom Long will take us through the cases they discuss. The moderator there is Michelle Goodwin. And I think it's interesting that this year, the panelists consists of 3 journalists and 2 law professors. I think in the past, it's mostly been lawyers or judges. So I think that's an interesting drift. Anyway, if you do have questions, please put them in the chat. Anne will be monitoring the chat. And when it's appropriate, Judge Long will take questions. So Judge Long graduated from Stanford University undergrad and law school, and he practiced law for over 30 years. And during this time, he served on RPV as a member of the Planning and View Restoration Commissions, City Council, and as mayor. Jerry Brown appointed him to the bench as a Superior Court judge in 2015, and the public has affirmed that appointment by election ever since. We are beyond lucky to have Tom as an active member of this club. He has been so generous in sharing his judicial expertise with us, particularly this time of year when he reviews the Supreme Court decisions of the previous year. So please welcome Judge Long, and the first slide, please, for the first case.
Okay, we're going to go straight into the first case, which I think is the most important one on voting rights. And we'll talk briefly about that afterwards.
This is as loud as I can make it, but let me see.
Do we want to go ahead and put on more case?
Moore versus Harper?
Yeah.
Okay, you ready to go with the first case, Tom? Is that it?
Yes. And before we started, just one comment sort of overall about the Supreme Court. This whole discussion of the Supreme Court reminds me of, the bleak part of It's a Wonderful Life, where Jimmy Stewart is looking at everyone gathered around and the police sirens are wailing by. Things are not as bleak as they seem. So keep that in mind as you listen to the discussion of the cases. The first one is the most important case of all the cases this year compared to all of the other cases combined, and it had the right outcome. So let's look at the discussion of the Moore case.
Court. So I want to start with voting rights, and I'm looking at you, Jamel Bowie from the New York Times. Thank you so much for being with us. Tell us about Moore v. Harper, and then also if you want to add in a little bit, and maybe Mario, I'll pitch to you, Alan v. Milligan.
Sure. So Moore v. Harper is the case out of North Carolina involving a highly gerrymandered federal congressional map. And the state Supreme Court said this map is so gerrymandered that it violates actually the North Carolina state constitution. So
that says a whole lot.
Right. Right. I'm from the South. I'm a Southerner. I have lots of affection for the South. I'm from Southern Virginia.
Okay.
So basically from the North Carolina, like near the North Carolina border, I have a lot of affection for my brothers and sisters in North Carolina, but that is not necessarily a state where courts say, oh, this is so bad that you can't do it anymore. But this map, in fact, was so bad that they couldn't have it anymore. And so the court says, we're going to do a new map for upcoming elections. The Republican legislature sues, essentially saying that, no, you don't have the right, you don't have jurisdiction to strike down this map. That under Article 1 of the Constitution, under the elections clause, it's state legislatures that have what they said was plenary authority to deal with federal congressional maps, deal with districting, deal with sort of elections. And the state Supreme Court has no say over what we want to do. Now, the Supreme Court, heard this in his opinion. Roberts essentially said this is just not the case. that the actions of state legislatures are bounded by state constitutions. Roberts, in his opinion, also leaves some wiggle room for the Supreme Court, saying basically that we are the final decision on the legality of, say, a congressional map, say some aspect of federal elections. But the point I want to make real quick is just the fundamental insanity of the claim being made by the North Carolina legislature, and by the claims being made by those who supported the North Carolina legislature in this dispute. One of the fundamental facts of the creation of the U.S. Constitution is that it was a response to the actions and behaviors of state legislatures. Prior to the 1787 convention, Madison writes what is kind of a screed about the actions of state legislatures, how they are making it impossible for the national government to exercise power, how they are overstepping their bounds, how they have rendered the Union essentially functionally unable to operate. And so much of the federal Constitution is written specifically to limit the authority of state legislatures. This is, in fact, was one of the causes for opposition to it, that you're taking away authority that properly belongs in state legislatures. And so to turn around and say, well, the Constitution thus gives this seemingly unlimited power to state legislatures to structure federal elections just doesn't make sense on its face.
So I want to turn to you, Mario, because I know this is a case also that you were following, and also Alan v. Milligan. I mean, these cases have racial implications, right? In fact, I almost thought it could have been my own Freudian slip when I heard you say, Confederate state, right? Because, I mean, look, let's just be clear, right? We could draw Venn diagrams, right? And see how these matters align. Race matters.
Right.
I mean, we can't pretend that it doesn't in a state like North.
You didn't read SFF.
I mean,
just checking.
check, please. Well, right. I mean, we're at a time where in Georgia, you can't give someone a cup of water or a sandwich if they're standing in line for 7 hours to vote. That's if they have the capacity to be able to stand.
Well, so race does matter, certainly in the voting context historically. Few or nobody should deny that. But if we add in Allen versus Milligan, race was the question in that case.
What
right?
was the question, Mario?
So we have Alabama post 2020 census has to redraw districts. It has 7 districts. Prior to 2020, it had 1 sort of majority Black voting district. But you have changes in the population in the 2020 census where the African-American population increases, and suggests that in the redistricting or remapping that you would end up with a greater number of majority Black districts. But because of the way the map is drawn, that doesn't happen, which causes the plaintiffs here to raise a challenge under Section 2 of the Voting Rights Act, which presents discrimination based on race or protected groups. And the question becomes, does Alabama have the authority or autonomy to draw the map in this way and to fail to create a larger number of Black majority districts? And I will say, to me, this is actually the surprise of the term in some ways, because many people thought there was enough room for the court to interpreting the standard that's most relevant, a 1986 case called Thornburg versus Jingles. Thornburg versus Jingles. I resist. It seems like lighthearted when it shouldn't be. Right? Interesting thing in Alabama, maybe there are 2 interesting things. Is the first would probably be that the district court in Alabama actually found in applying the standard from Jingles that the plaintiffs were correct, right? Which is that standard sort of says if you can prove that you are a large and compact minority group, that 2, you were politically cohesive, and 3, that your vote would be frustrated by the white majority, that you should have the right then to contest the drawing of the map. And why I thought it was the surprise is because with the new sort of conservative supermajority, I thought you could just interpret the case to determine that in applying Jingles that the state was fine in how it drew the map. And the state didn't put forth a really, I guess maybe Jamel you can tell me if you agree. They didn't put forth a robust sort of explanation for how they had come to move.
It's hard to justify
that. Put Black citizens across. And their one claim about the maps that the plaintiffs offered that would have created multiple majority Black districts was, that will affect the contiguousness of the Gulf region, I guess was and so my sense was, that you got Chief Justice Roberts and Justice Kavanaugh joining the sort of what we now might imagine is the more liberal minority of the court to suggest, and this is why I don't want to make it a larger decision than it is, that the district court in the way in which it applied the jingle standard had applied it in a way that was defensible and that majority was not willing to
I want
overturn.
to open this up a little bit in terms of why this matters as well, right? Because we're talking about creating the kind of gerrymandered maps that really dispossess people from being able to elect officials that will represent them and their interest. I mean, that is it at the bottom line. Jessica, I see you nodding. Mark, you've joined in. You're nodding, Maura. So quickly, before we wrap on that, what would you like to add?
I just want to add, I think that Milligan is a paradigmatic case for this term, because what happened was Alabama got the new census numbers and said, oh yeah, we're going to gerrymander Black people out of power. That's what we're going to do because we see Brett Kavanaugh and Amy Coney Barrett and John Roberts on the Supreme Court. This is our moment. And we don't think that this court is going to enforce what remains of the Voting Rights Act. And they litigated this to the Supreme Court in an incredibly sloppy and arrogant way. Alabama's Attorney General put forth a truly bizarre argument that basically, if you read the Voting Rights Act to mean what it says, that it is unconstitutional because it is a violation of equal protection to simply look at race to decide whether a map is unfair. And I think that offended Roberts and Kavanaugh. And I think they said, you know, we may be hacks, but we're not your hacks. Like we
may be crazy, but we're not.
Okay. But so this is exactly what happened in the case that Jamel was describing, the independent state legislature case. This is what happened in the Indian Child Welfare Act case as well,
which
where
we're
you
going to get to
sizable majorities looking at the way that in the Indian case, Texas, and in the North Carolina case, of course, Republicans in the legislature tried to put forth these cockamamie theories and barely bothered to do the homework, right? I mean, this was just ridiculous.
In part, if you look at the term last year, right? Again, we could just take Dobbs in the state of Mississippi, you know, just what an outlandish kind of suit to bring forward altogether. And if you can win in Dobbs, if you can win in Bruin, the, you know, one after the other, on one hand saying that, you know, a state that has legislation that's more than a century old, that doesn't matter. And then on the other hand, flipping it entirely, maybe bringing sloppy to the court, folks thought would be okay.
Right. But it turns out that the three justices who are sort of in the middle, still very conservative, but in the middle, Roberts, Barrett, and Kavanaugh, they have a very specific agenda. And
what
if the case falls, well, so I think these are all creatures of the Reagan Revolution, right? Like John Roberts was in the Reagan Justice Department opposing the part of the Voting Rights Act that he just upheld, which is sort of weird performance art. You know,
Shelby County Beholder, right?
Yes, Barrett and Kavanaugh, very similar. And so I think when it comes to something like today's decision about, you know, carving loopholes into civil rights laws and anti-gay discrimination, they're there. They're like, yes, this is my dream. All I want to do is let businesses discriminate against people I don't like. But when it comes to something
religious reasons.
Yes, that's right. When it comes to something like you know, just dismantling this really important law protecting Native children or giving state legislatures absolute authority to rig elections, they're saying, we're not there yet. We will set the agenda. You know, like we were ready for Dobbs, we were ready for Bruin, but give us a couple years before you start assailing us with these big blockbuster decisions that we don't have the capital for right now.
Okay, well, that helps to set some of the terms. That's the first question. And let me just say to the audience, Irwin Chemerinsky wishes he could be here. Last night he called me at about 9 p.m. And we were going to try, I was going to try to do something special where you could hear the voice of Irwin. Seriously, we were going to try that, but unfortunately his laptop was left and it was a try. Okay, but he tried, you know, he tried, he really wanted to be here.
That's the end of that clip then, the discussion and more?
Yes.
Okay. So were there questions before I made a couple comments or? Well, let me just emphasize why I think this is the most important case. And the commentators sort of touched on the outskirts of it, but in the end, part of the theory that was being offered was the so-called independent state legislative theory, a theory by which every state legislature could just do whatever it wanted to without any constraint by either state courts or federal courts. And so that could go as far as being part of the plan to alter the 2020 election by simply saying, well, we'll just have state legislatures appoint somebody, appoint electors different than the electors chosen by the popular vote, and the state legislature would have the power to do it. If you discuss some of these kind of issues with colleagues who are Republicans, which I periodically do from time to time, one of the questions I've asked them is, can we at least agree we live in a democracy? And the answer I get is, well, we live in a constitutional republic. So in a sense, the answer I'm getting is no, we don't live in a democracy. And if the outcome on this case had been different, and this is why this case is so important, if the independent state legislative theory had been accepted and the outcome on this case had been different, it's not just that it would have impacted this case, but that it basically would have said, we don't live in a democracy unless the 50 states from time to time decide to follow democratic norms. And they would have had the ability not to follow those norms if that's what they'd chosen to do. Now, of course, the issue of districting, when we get to the case that talks about affirmative action, the Harvard, North Carolina case later, one of the dissents made a comment there that I thought was very interesting, which is you can't pursue equality unless you know what the inequality is. And in this case, the inequality is not just necessarily that you don't have 2 majority Black districts in Alabama. Instead, you just have 1. It could be just the whole way the redistricting is handled, which is a race-conscious way of handling it in Alabama, which is you sit back, as the state legislators, I think, do if we were to really learn the truth here, and they do what's either called cracking or stacking. You either spread the Black votes far and wide if you can, so that they don't control the outcome in any district, and you reduce their representation to 0. That would be called cracking. Or you do what's called packing. You put them all into one district, and even though they're 30% or so of the vote and should have 1/3 of the districts, you put them into one district, and that's what they end up with as their representation. And you only do that to the extent you figure out that you can't crack their vote by spreading them far and wide. And what the Supreme Court did in saying no is revealed to us a couple of things. They revealed to us we still have 6 members who are willing to protect fair election rules and who do think of the country as being a democracy. So in a sense, we have, as I've suggested to other people, 3 wings in the Supreme Court: the liberal wing, the conservative wing, and the authoritarians. And the authoritarians are the 3 who voted in the minority on this particular case, because they are the 3, in my view, who are against democracy. And when I took the oath to uphold the Constitution against all enemies, foreign and domestic, they are the domestic enemy. That's a harsh thing to say, but the logical outcome of an independent state legislative theory is that you no longer have a democracy. There is no constraint and no fairness of elections. So that's why, more than all of the other cases combined, as disappointing and as much as the other cases got much more publicity and as disappointing as the outcome on a number of them is, this is an incredibly important case, and the outcome was the right one.
Tom?
Yes.
Who was the 6th justice? You mentioned Roberts and Kavanaugh. Who was
Amy Coney Barrett would be the 3rd
Okay.
in the what I would call the conservative wing. So it's 3, 3, and 3. Alito, Thomas, and Gorsuch are the authoritarian wing.
Yeah.
And I say that just focused on this case. Sometimes, depending on the issue, things will shake out differently. And for example, Gorsuch is very open to protecting the rights of Native American tribes. So, you can look at him and say, well, he's an authoritarian when it comes to election rules, but maybe he's not an authoritarian across the board.
Anne, were there any?
Yeah, so we have one question from Mayron. He's asking, is the North Carolina legislature pushing through new state legislation now?
Well, I don't know the answer to that question. I'm sure North Carolina legislature will have to, will do so. This case will impact lots of different districting decisions that are made wherever they may be made, and it'll have a considerable impact. And you can't just rely on the notion that you'll be able to sit back and just say, well, the legislature has complete discretion. Under this case, it clearly doesn't have complete discretion. There is some viability left to the Voting Rights Act.
But Tom, this was ruled, but the legislature doesn't seem to be following the rules.
Well, if that's the case, what'll happen is that
That's Alabama. I think you're confusing it with Alabama, Carol.
Yeah, you may be. Alabama did disobey the prior decisions that impacted it. At least that's my view, and that's going to go up to the Supreme Court, and that'll be decided before the 2024 election, I'm sure.
Okay, well, I didn't know that North Carolina was following the rules either. I mean, I don't think they've come up with anything, and I just wondered what power the courts have.
Ultimately, the courts have the power. If the state legislature doesn't do it, the courts have the power to draw the lines. So the courts will, I would expect the courts to be directed by the Supreme Court that if, you don't get a compliant map from the legislature, or if we decide that a map you think is compliant isn't compliant, you or we or somebody will draw the lines for the state legislature, and those will be the lines that the Secretary of State will be ordered to use.
Okay, we're ready for the next case, Reggie.
That case is Creative LLC versus Elanus, and this is the web designer that was allowed to discriminate against LGBTQ.
So 303 Creative, Maura, let me turn to you. What is that case? What is it about? And tell us about this 6-3 ruling.
So 303 Creative, it's a little bit of a rerun. It's very similar to a case that the court rejected about 5 years ago called Masterpiece Cake Shop. And the facts in 303 Creative are that a woman named Lori Smith living in Colorado says that she wants to expand her website design business, which she asserts is a creative business, get it, 303 Creative, that is expressive and customizable. And that she, because she is a religious conservative, believes that same-sex marriages are, to use her phrasing, false. And so she does not want to be compelled, as Colorado civil rights law would compel her to do, to treat same-sex couples seeking a wedding website the same way she would any other couple seeking that service. And in fact, she wants to be able to put a sign at the homepage of her web design business saying that she will not provide that service to people whose marriages she believes to be false.
Can I add one thing right here?
Yeah.
So great setting of the case. One footnote that's important. No same-sex couple has ever asked Lori Smith to publish a website for their wedding. And if you look at her webpage, you will understand why. Okay? Like, don't flatter yourself, Lori. Bursting through your door trying to hire you, but sorry, Maura.
This is actually the Chris Stone case, but okay. Mark Joseph Stern, Slate, Maura Donegan, The Guardian. Okay, all right, let's.
Well, this is actually a point of contention, Mark,
right?
Because Smith's legal team asserts that within 24 hours of her filing this lawsuit, she in fact did receive a request from a man named Stewart to create a website for his wedding to a man named Mark. They had, what was supposedly this man's request, along with his contact information. Melissa Maria Grant, who is a reporter at the New Republic, reached out to Stewart to ask him about his request. He had never heard of it. He had never made such a request. He lives in another state and is, in fact, married to a woman. So, the veracity of that claim, might be a bit dubious, but the Supreme Court, sort of impervious to these facts and to Smith's lack of standing, granted cert on Smith's claim that following Colorado's civil rights non-discrimination ordinance that prohibited her from discriminating on the basis of identity in her public-facing business would violate her freedom of speech, right? She says, me making this website is, you know, a cry of my soul, and the Colorado civil rights law requires me to either speak in a way that I find false or to remain silent. And they found that she has a right to discriminate.
Her soul has a right to scream.
Yes.
And, you know, this is, you know, the facts of the case are kind of silly. As Mark pointed out, there's not really standing here. There's no real injury that has happened to this person, but the implications of 303 Creative, I think, are very chilling, not just to same-sex couples, but because the decision that was handed down, authored by Neil Gorsuch this morning, really has no limiting principle. It's kind of it's very imprecise in what kind of ability to discriminate it licenses. In, you know, it sort of collapses the distinction between speech and conduct, and it establishes this precedent that people who are, you know, using and engaging in the public market that the state helps maintain don't have to follow the state's rules that are designed to help, you know, create a pluralistic society. And it's also just like so fearingly insulting that she can put up this sign that says, I think this genre of person, this identity group matters less and they are offensive to me. And so I will refuse to engage with them as I would in any other matter.
So Mark, so one of the refrains that you hear people say, well, okay, well, why would anybody want to take business there? And so no harm, no foul, because no one would want to do business with someone like this.
Right,
woman.
but of course, this was a test case that was devised by a group called Alliance Defending Freedom that has been trying to get the Supreme Court to do exactly what it did this morning for many years. And so, as Justice Sotomayor put it in her brilliant dissent, you know, there really is no clear limit. The majority says this only applies to expressive conduct, but what does that encompass? And she uses the real example of a funeral home in the South that would not hold a memorial service for a gay man because he was gay. And she says, is that expressive conduct? And I think the majority would say yes. And I think if you go even further, you can recast anything as expressive conduct, right? The guy behind the counter at Dairy Queen is suddenly an ice cream artist, right? And when he pours the swirl, he's expressing his love for the customer, right? It's a ridiculous idea, Jamal, sorry.
No, Jessica too, well, Jamal and then Jessica.
I wanted to really emphasize that point that anything can become expressive conduct, and let's use food service as another example, as a serious one. In fine dining, the dish is an artistic piece, right? It's a piece of art. It's consumed, but it's conceived as an aesthetic object that is expressing something that the chef is doing. So under 303 Creative, is it viable for the owner of a fine dining restaurant to put, I won't serve blacks because I don't want to express the opinion essentially that blacks are able to appreciate the things that I'm doing? Like, once you start to take it very seriously, and once you recognize, as Maura pointed out, this collapse of speech and conduct,
where is the limiting principle?
Right.
And I want to add you into this, Jessica, too, because that also brings to mind individuals who may be perceived as having non-documented status. I mean, we saw this during a time during the Trump administration and even before, people who would think that they were going to be doing their own policing, right? If you looked at whatever that means, look non-documented, you can't come into the store, right? It brings added weight to the example that you just offered, right? My business is not for people who shouldn't be here. And what does that mean to belong in the first place?
Justice Sotomayor, in her excellent dissent, also pointed out, why can't a website creator refuse to make a website for an interracial marriage on the grounds that she doesn't think that races should intermingle? How does the Supreme Court majority distinguish that context from a same-sex marriage? I read the opinion quickly, so I don't know if they addressed that analogy. I was a little worried during the oral argument that the Supreme Court might say something like, rights to freedom against discrimination on the basis of sexual orientation are less weighty or less important than rights to freedom against race discrimination. I didn't see that in the opinion this morning. I hope I didn't miss it. So I'm glad at least that they didn't go there. I am a little worried about a comment in there that Justice Gorsuch said that if the same-sex couple were to prevail in this context, then it would lead to a situation in which anything that somehow implicates a protected trait could therefore be forbidden speech. And that worries me because marriage doesn't just implicate a protected trait. I mean, same-sex marriage is central to sexual orientation. Same-sex relationships are, and he seems to be missing that. More broadly, this opinion is very sterile and logical and formalistic. And for a justice who cares so much about religion, it very much lacks a soul, in my opinion.
Part of Atlanta Hotel just needed to suggest that the clerks there were engaging in expressive conduct when they discriminated on the basis of race, and then we wouldn't be able to uphold Title II. I mean, it's that kind of like.
Okay, so this is a difficult and sort of complicated case, and I disagree with the commentators somewhat in terms of thinking that it has, and I guess the first time I read it, I thought maybe it has a broader impact, but the more I think about this case, is it should have been dismissed as being a bad case for the Supreme Court to decide, a bad case to draw lines in. At one end of the spectrum, we all know there are public accommodation laws. Who can get a room in a hotel? Who can get a table at a restaurant? And I think, you know, I would argue this case doesn't disrupt any of those expectations because it basically doesn't touch on them at all. It doesn't touch on them at all because Colorado, wisely or unwisely, stipulated that what the plaintiff was doing was pure speech, whereas renting a hotel room to someone, serving someone dinner at a table, those are not pure speech. Those are more conduct than they are speech. The public accommodation laws, civil rights laws remain in place. They are not unconstitutional. The fact that your religion tells you to discriminate against people is of no consequence. You don't have the authority to do that, and this decision doesn't protect you. On the other end, imagine the hypothetical. You're a flag maker, and is what you do really pure speech? Maybe it's part speech, part conduct. Well, what would you be required to do? Say I'm the leader of the local Nazi party, and I want you to make me some Nazi bands that I'm going to, Nazi flags that I'm going to use, and Nazi armbands that I'm going to use to have my group march down the street in Skokie, Illinois, which we know from prior Supreme Court decisions they can do. So this case was supposed to be, I guess, a case to decide where the line is between public accommodation and expression and pure speech. But because the state of Colorado stipulated that the plaintiff was involved in pure speech, without us really knowing what any of the facts are, for all I know, she's just designing a website and isn't responsible for any of the actual content. She just does the coding necessary to set up the website that the client then provides the substantive content for. So since we don't really understand the case very well, and I don't think the Supreme Court understood it very well either, this is a case where they should have dismissed certiorari as being improvidently granted. And if this case is cited as precedent in the future, I think those arguing for a different outcome should simply be saying, well, it's not precedent for anything except for things that are exactly the same on the facts. And this case was stipulated to be a case involving pure speech. And very few cases involve pure speech. So this case means nothing. It just is not viable precedent. As Erwin Chemerinsky pointed out in a recent article to the Daily Journal, you know, a lot of these new Supreme Court cases appear to be overruling prior decisions, but the Supreme Court doesn't say it's overruling prior decisions. Now, maybe it's not being honest, maybe it really is, but no, I would say that when the opinion of the court does not say a prior decision is being overruled, the prior decision is not overruled, and you have to find a way to reconcile the cases. And the way I reconcile the cases is saying that this one is limited to precisely the facts stipulated to by the parties to the case. Do we have questions about this case?
Oh, no, and more comments, so people can read that in the chat. It's just more comments. I think you answered what they were saying.
Okay, I think we should, and this'll come up, I guess I keep coming back to something, and when I listen to these commentators, I got a little bit discouraged by them because everyone is taking the approach of, oh my God, these cases have this broad implication. Look at what the Supreme Court is doing, making all these broad new rules. And the more you think about it, they're really not doing that, either because they don't know what they're doing, which I think is part of what's going on, or they really don't want to be as bold as some think they want to be. They're really picking and choosing cases, and this case was a poor case to pick, to try to lay out some criteria, to try to lay out some line drawing between other cases. Really, this case is, I think, will be put aside sort of in the trash heap of history, minor footnote, not being of any real consequence. Let's go to the next one.
Well, were you going to talk about the FDA versus the medicine?
Oh, yes, I'm sorry. This is the spot where we're going to talk about the methylpristone cases. And I don't have, and someone will want to touch on it. We'll have a quote from one of the cases that someone may want to touch on. But the point I would say about those cases is it looks like the carefully selected forum shopped judge, federal district court judge in Texas, who ruled in favor of undoing decades of regulations of this abortion pill, got support for that outcome of undoing the regulations and basically saying that, the FDA's approval can't stand, got support from the Fifth Circuit, but the Supreme Court is going to take up the case next term. So it is preserving the status quo. The abortion pill treatment, methylpristone, will continue to be available pending the Supreme Court making a decision. So the issue isn't really being made today, isn't being decided today. And the lower court decisions are really, in the end, of no consequence because they're not being enforced now. The U.S. Supreme Court, it'll be part of coming attractions for the next term.
And were you going to address Judge James Ho's reasoning in the August 16th Fifth Circuit decision?
I wasn't going to do that directly. In the end, I don't think any of the decisions by the lower courts are going to make any difference. I think that the Supreme Court's going to look at the issue anew with the briefing that is brought to it. And the Fifth Circuit and the district court decisions are really just also going to be relegated to the trash heap of history.
Okay. We were going to talk about ethics and the court, and I believe that is the next segment. Am I right, Reggie?
Yes. Uh-huh.
Okay.
Yeah, I think we kept a portion of that. Let's go ahead and play that chunk.
It's a fairly long segment.
Right, where to begin? Boarding schools being paid off by donors, mothers having homes purchased and fancy trips.
I think.
It was the auntie. It was the auntie. Auntie got a house. I think it was Mama got a house. Okay, all right. But there are many people who are concerned about the Supreme Court, its trustworthiness, whether it reflects the American population. One could certainly say that it is a group of elites, even if we weren't talking about these cases, right? It is a group of people who, for the most part, have graduated from basically 2 law schools. Yeah. Amy Coney Barrett presents, an alternative to that, but that's just one of the justices. It's a court that, in its over 233-year history, has not been very diverse. Only recently has had its first Black woman that has now been confirmed to the court, Justice Ketanji Brown Jackson, who just is concluding her first term. But all of that said, it has the lowest approval rating that it ever has, since there have been polls about how Americans understand the court. Your thoughts about the court, ethics, et cetera, from Alito to Thomas, et cetera. Who wants to begin?
I mean,
Jamal, why don't you begin?
Yeah.
Yes.
So I put this judiciously. The court, there's strong evidence to suggest that the court is incredibly corrupt.
I guess.
It's not where I thought you were going.
He paused, though, for selecting his words.
when it comes, I mean, we know the details, right? That Clarence Thomas has essentially this sort of billionaire patron friend who provides very fancy gifts and vacations to him. Sam Alito has been the recipient of some of this. Justice Scalia, when he was on the court, was the recipient of various forms of largesse, you know, hunting trips, lodges, that sort of thing. This has been part of, at least, and that's that part of this ideological wing of the court, part of their behavior is readily and without any sense of any lack of propriety or anything, just taking gifts from wealthy people. I myself have a few theories of what's going on here, and I mostly see it as an attempt to ensure that the conservative justices, and particularly the ones that are coming very much of the conservative legal movement, do not begin to take their independence too seriously. And connecting the justices to awards and dinners and trips and gifts and all this stuff isn't so much to get them to rule a certain way necessarily, but to create strong social ties with the conservative legal movement and ensure that what they're worried about is not so much the public opinion or not so much sort of mainstream political world, but the esteem of their peers within the movement.
It seems that what you're suggesting is that the power behind it is pillow talk.
Right.
It's about doing the soft part.
Right.
That ultimately carries.
This is an interesting point. It's one that's been made repeatedly by Corey Robin, who's a very interesting biographer of Clarence Thomas and an observer of the court. He says that, you know, it's not necessarily corruption in terms of just straight quid pro quo. Like, I will take you on this very fancy fishing trip in Alaska in exchange for this kind of ruling where I have interest before the court, although, you know, there is an appearance of that happening, but that's not necessary for corruption to be there. What there is sort of a density of social ties, a sort of surrounding of influence and suggestion and connections to these interests that doesn't need to be as crass as you know, a sack of cash with a dollar
sack of
sign on
coins.
it. Yeah.
The problem is it's patently unfair. I was a former government attorney. I was in the Navy JAG Corps for more than 20 years. As a government attorney, you have the Office of Government Ethics, Standards of Conduct, which limit the gifts you can take, the amounts. They're highly regulated. You can be prosecuted if you violate it. Federal judges, lower than the Supreme Court, have ethical standards, which they have. The fact that the court itself sort of is without any sort of standards which limit you know, ethics is a problem, mostly because of what Moira mentions, which is, I agree, I don't know that there necessarily is any sort of quid pro quo, but what you're regulating is the appearance of impropriety, because what happens is it undermines the legitimacy of the court with the public.
I mean, well, truth be told, law students are held to a standard.
A higher standard.
No, seriously. I mean, they are, right? I mean, before they can even take the bar exam, their character and fitness has to be assessed. And that is assessed at the law. There are many things that they cannot do where they may or not sit for the bar. And so when you say it is a higher standard, that's not hyperbole at all.
It is a standard.
It is a standard. There is a standard. Mark, I don't know if you wanted to add anything to that before.
I mean, just briefly, it's like they can take all the private jet trips they want. They can go on all the fishing trips they want. They can travel around the world. All they have to do is disclose it. That's all that they are asked to do.
Disclosures.
And they refuse to disclose it. And when called on this, and we saw this from Justice Alito, they act so aggrieved. How dare you question my conduct, right? Justice Alito, knowing that there was going to be an expose about him, published a pre-buttal in the Wall Street Journal saying the lodge may have been very expensive, but to me it was rustic. And You know, we may have had some wine, but I've had $1,000 wine before, and that wasn't it.
This is no screaming eagle.
Yeah. I mean, it's ridiculous. And I just want to tie this to like the broader point. Only recently have SCOTUS reporters started reporting on these guys like public servants who deserve scrutiny. Yes. For decades, they have been able to operate totally above suspicion. They are so unprepared to handle that scrutiny. And that is only just becoming clear. And it's going to be a huge problem for them moving forward.
Can I add just to tie this to maybe like a larger structural observation about the court, which is that, you know, one of the hallmarks of the modern political order in the United States is the court is understood to be kind of the exclusive interpreter of the Constitution. This is unusual historically, right? The FDR's court packing scheme was as much a claim of FDR saying, I think the executive branch has a right to say what the Constitution means, as it was an attempt to get a favorable court. And you can look back to Lincoln, to Jefferson, to Jackson, right? You can look at presidents and Congresses pushing back at the court's interpretation of the Constitution. But for the past 50 years, the general consensus has been the court is where it has the final say. And I think what has happened is that the court itself has begun to see itself as essentially above the constitutional system, right? It's existing not simply as one of three branches that can be checked and limited by the others, but as like a super branch that controls the conduct of the other.
Well, this is Jamil, I think you're pointing out something very true that's relevant to the conduct of the court over the past few terms, especially, is that the court is really taking advantage of the gridlock in Congress, right, and the impotence of the legislative branch to check it. Like these corruption stories that have come out, and I think, you know, we would be remiss if we did not credit the excellent reporting of ProPublica, who have done an
Incredible
amazing
reporting.
job.
Absolutely.
But this has not been met with silence from the Judiciary Committee. It's been met with a Judiciary Committee that is incapable of doing very much. It doesn't have the votes to issue a subpoena. It doesn't have the ability to say anything beyond like, pretty please, John Roberts, will you come testify? Pretty please, right, Carling Pro, will you come testify? And they get these letters back telling them to kick rocks. And that's because Congress is weak, that the judicial branch has both colonized a lot of policymaking power and also become, you know, indifferent to the efforts to check its really reckless expansion of its own prerogatives.
I did a couple of posts to my LinkedIn page, which you might want to read, that have the ProPublica articles and the responses by Alito to them, which I think are a useful discussion. All I can say is the Supreme Court justices depart from ethical rules, not only that we have for state court judges, which are far more stringent, but even the rules that are applicable to their federal colleagues at the district court and court of appeal levels, circuit court of appeal levels. So, you know, the problem is there is no effective check on them. The threat of impeachment is so remote because it would require a majority in the House and 2/3 in the Senate that they can act with impunity. And it doesn't have to be quid pro quo. In fact, I don't think at this point there really is any evidence of quid pro quo. There's simply evidence of the kind of conduct which really just stains the judiciary and stains everyone associated with it, and makes it look as though either our Supreme Court justices are extremely unwise, extremely unintelligent and naive, or in the pockets of the people they're getting money from. I mean, at least Justice Thomas will say, well, these are long-term personal friends of mine, and this is just hospitality. But Alito, if you read his pre-buttal to what was said in ProPublica, he actually says, well, you know, not only was this just a rustic lodge and I didn't get $1,000 bottle of wine, but he also says basically that, you know, I didn't even really know this person that well. Well, having been in an elected position as a city council member, certainly you know, and just being a person who's not, you know, born yesterday morning, I understand the concept that if someone is showing expensive hospitality toward me and I don't even really know them very well, that's really a reason to stop and say, you know, I really can't accept this, because whether or not someone's asking for a quid pro quo, it just creates the wrong image. It causes distrust of government to grow, and it causes people to be suspicious of the merits of the decisions, even if the decisions might otherwise be perfectly good decisions. Any questions on this area before we move on?
One question is, when Kavanaugh, this came from Mayron as also in terms of the conservatives, but when Kavanaugh and Barrett were evaluated, and would they vote on Trump cases, should they be looked at? So when they were evaluated, should that have been looked at in terms of their ethics as well?
Well, I think so, but the problems are so pervasive, and all 9 of the justices have signed on to the lackluster sort of whitewash approach that Chief Justice Roberts is taking, that the problem with the current Supreme Court is so extensive that it's not just an issue of, oh, well, we need to, they need some sort of an ethics code, and they need somebody with some power to decide what's going to be done to discipline them. And maybe it's going to even require a constitutional amendment. I mean, what we have at the state level, we may even have a member online here attending our meeting. We have what's called a Commission on Judicial Performance, which is an independent commission, not a political creature. And it is the body that handles ethics issues relating to state court judges. And it would be useful to have something similar. And if Congress really were of a single mind and were willing to do that and say, look, the CJP at the federal level wouldn't have any teeth because the Constitution doesn't give it any teeth. But if the Congress were to say, if they recommend to us that we investigate someone, we will follow through. We will impeach them and we will put them on trial and see whether or not they get convicted. But it's a serious sort of pervasive problem, and it goes beyond just the issue of, well, is someone deciding cases that impact the president who appointed them? I mean, that worries me a lot less than sort of a pervasive problem that we don't even know because the disclosures aren't even being made. I mean, I own some individual stocks. I'm required to make disclosures, and I make disclosures every time. If someone comes in front of me and they're adverse to a company I own stock in, I disclose the amount of stock involved, and periodically I end up having to recuse myself unless both parties agree it's not necessary. So
he's also asking if, in your 333, in terms of the progressives, the conservatives, of the conservatives, do you think they'll vote for in the January? Which way do you think they'll vote in the January 6th conspiracy case if it ends up coming to the Supreme Court?
Well, that's getting way ahead of our skis. That's maybe something not even for the next term, but for the term after that or the term after that, because I'd have to be commenting on an appeal from a case that hasn't even been done yet. And what would the appellate review be? What would be the potential errors that were made at the trial court level? Well, the trial court hasn't done much of anything yet, so we don't know.
Right.
I think that's just premature. That's coming attractions. Coming
attractions that we're all waiting on.
Yes.
Okay, we're ready for the next case, Carol.
Okay, that one is Students for Fair Admissions versus Harvard, and that was a 6-3 decision. And as well, there was Students for Fair Admissions versus North Carolina. The ruling claims that affirmative action violates the Constitution. This includes criticism of Thomas, and it includes the carve out for the military. And so, Reggie, could you go ahead and show that?
Let's turn to affirmative action, right? Students for Fair Admission. Yesterday, the Supreme Court ruling 6-3 in one of the cases, the North Carolina case, because Justice Ketanji Brown Jackson could participate in that. She recused herself from the case that involved Harvard, where it was 7-2. And so let's see, Mark, why don't we begin with you in terms of that case?
Well, the Supreme Court said racism is over. And per Jamel's observation, the other branches have no choice but to nod along. I'm oversimplifying, but what the court did through Chief Justice Roberts' majority opinion was essentially ratchet up the scrutiny that's given to affirmative action programs so much that no program as it currently exists can continue to operate, which is really, I think, a catch-22, because what the court has done here over the last 50 years is say, you can't have quotas, you can't have any kind of measurable standard for building out diversity. All you can do is look at students holistically and try to use like race as one of many factors. And in this decision, Roberts scolds Harvard and UNC for not having any manageable way of measuring race and diversity in the class. And that's because the court said it couldn't do that.
Yeah.
They would have gladly done it, but the court says no.
Mario.
Okay, so I want to say when I first read it, I was expecting it, but it did put me in a position of saying, what are colleges and universities supposed to do where they do believe there is an educational value in diversity? Race is one of the things we think is important.
And former dean of a law school. Yes.
And a state like California, where under the state constitution, you're not allowed to consider race as a factor. And so my sentence was to try to look at it and said, what remains of affirmative action, if anything? Because for those of us who were hopeful that after Fisher, this would be another tweak rather than taking the bulldozer to it, what you would have done is to say, well, you know, on the standard of you must have a compelling interest and narrowly tailor it, that they would have tweaked narrow tailoring, saying these plans have problems, but that, you know, moving forward, you know, diversity is still a compelling interest. The problem is they completely undermined the compelling interest standards by saying there were no measurable standards. There were problems between the means selected by the schools and the goals themselves. Then they resurrected all of this dicta from cases that we had never thought was controlling to add, now you can't use race in any way that negatives any other applicant. You must have an absolute sort of date certain for ending if you want to have. So there were all these things that had been mentioned in various ways that now seem to have been elevated, but the saving grace, if we have one, and maybe you can tell me if you agree, Jessica, is they didn't out and out overrule Fisher. They actually qualified Fisher. Fisher was not justified on the same justification that Harvard and UNC, you know, training
and
lead.
just a little bit about the Texas Fisher case.
So that was a case in which it was the law school, the Texas was using race measures that they said it was a critical mass that they were trying to achieve. Now, they didn't use any really measurable standards to define critical mass, but they didn't say it was to train leaders for the diverse world. And so there with Justice Kennedy being the fourth vote in favor because it was a 4-3 case, they said the way in which Texas had sort of exhausted every other way to create diversity, but the consideration of race as one among many factors in this was justified based on the critical mass. And what the Justice Roberts actually says is we are not saying that the Fisher case, which considered the critical mass, is at this point overruled. And so my sense is, however, the problem is, but if you come back with and argue critical mass, will you be held to the standard of now it has to be a measurable, defined standard? Because what Justice Kennedy liked about it was that it didn't create a quotient of how much race was enough.
But something I want to get to, and then let's talk about the dissent. Dissents, both Justice Sotomayor and then also Justice Ketanji Brown Jackson, because the conversation about affirmative action gets conflated. It gets diluted, many different things, right? And the reality is that Justice Thurgood Marshall, when he was a student, would not have been admitted to the University of Maryland because the University of Maryland discriminated against Black people being able to gain admission. Sort of the history before affirmative action was blatant state enforced discrimination. Right. And it's a part of our history that we don't pay attention to. Pauli Murray, who in many ways really preceded and you know, laid the ground for Ruth Bader Ginsburg, including at the ACLU. She graduated first in her class from Howard. She went to Howard, a historically Black law school because racial discrimination at America's school. She graduated first in her class. And of the work that she did there as a student, one of her papers was used in the arguing of Brown v. Board of Education. In 1945, in the California Law Review, she published an article about sex discrimination against women in employment. Polly Murray was a badass, but one that probably nobody's heard of because she was a Black woman. And she was at the ACLU long before Ruth Bader Ginsburg was, and left her files and her notes. So the things that we come to think about today of, oh, Ruth Bader Ginsburg, oh, Polly Murray, who had left all of this before. And Polly Murray had also had a scholarship from Harvard that was withdrawn from her because it was discovered that she was a woman. So on both counts, being Black and a woman, having experienced such tremendous discrimination, but whose work served as such a foundation for how we understood the arc towards justice with regard to sex equality and also racial justice. But the reason why I mentioned Polly Murray as sort of setting the tone for then thinking about the dissent is that Polly Murray leaves behind for us, she died long ago, but she leaves behind for us a book called Race Laws in America. It's about 800 pages, single space, about all of the racially discriminatory laws in the United States. If you're Black, you can't go into the park. If you're Black, you may not play checkers in public. If you're Black, you may not go to the bowling alley. If you're Black, you may not go into the front of the restaurant. If you're Black, you may not be in the taxi. This was America, not in 1872. This was America in 1952, 1962. And so then when we think about affirmative action, and I think that part of it is that many people think my child has a 4.3 GPA. These people getting admitted must be people who are deeply illiterate with maybe a second grade capacity for reading and writing, and not understanding that those foundations were explicit racial discrimination such that a Polly Murray, a Thurgood Marshall would not gain admission. So let's turn to the dissents. Who wants to start? I'm looking at you, Jessica.
I thought Justice Jackson's dissent very beautifully made the argument that racism is systemic, pervasive, institutional, and historical. And there is a deep disagreement on the court about what race means, what racism means, and what remedies are appropriate. And we see that illustrated.
Well, you see that tension too between Justices Brown Jackson and Justice Thomas.
Yeah.
I mean, it was as if
They
I was
each other in
thinking like switchblades. This is like West Side Story. You know, Justice Thomas, it just seemed to really go after her in many ways. It's like, oh, he pulled out a legal switchblade.
Never before has Justice Thomas served with another Black justice who is able to step up and defend affirmative action. And I think he was.
Or anything, or speak to racial history as a general matter.
Right. This is what I think is so significant about Thomas's concurrence, and the real sense in which he's going after Brown Jackson, because Thomas has grown accustomed over 30 years to basically be able to say, I'm
able to make stuff up.
I'm going to represent the Black perspective here. I'm going to represent this particular history. And Brown Jackson has consistently said you are misrepresenting the history.
Yeah.
You are misrepresenting. I just want to give an example of this. In his concurrence, he says he pushes back against the notion that the Reconstruction Congresses were using race in their policy making by saying, well, the Freedmen's Bureau.
Make that up.
The Freedmen's Bureau wasn't a reference to Black people, it was a reference to former slaves. Freedmen weren't necessarily, they weren't necessarily Black, QED. But I mean, first, that's like absurd on its face, but also the Reconstruction Congresses, one of the first bills that come out of this Congress is the Civil Rights Act of 1866, which is explicitly using race to attempt to ameliorate in particular, laws called black codes, right?
Yes.
That the black codes did not apply to freed people. They applied to black people in the
Yes.
states.
And in fact, just with a little bit of that history, right? Because this is a Supreme Court that has said that it is invested in history and originalism. And I think in part what Justice Brown Jackson is doing is saying, well, how I read history and how you read history is completely different. Right? Because I read history as the 13th Amendment abolished slavery and involuntary servitude. And that involved Black people.
Right.
And of course, if you read the legislative record and debates, it's all very explicit as the South is saying, no, those people are our property and we get to keep our property, right? It's very explicit. The 14th Amendment as well. And she's calling that out.
Right.
I was really struck.
Okay,
by
Jessica and then Mario, yes.
The majority opinion in recounting the history that led to Brown.
Never said slavery.
It's a shocking way that they describe that history is almost colorblind as the principle.
Almost.
That someone
Well,
is not
well, this is what they
based on
do,
racial
right?
stereotypes. It's bizarre.
So I want to speak across the dissents, right? So I actually think it is Sotomayor, which is the opinion that takes on both the majority and Thomas and sort of their reinvented and rewritten history, including the Reconstruction Congress, the statutes that followed, and what they meant to the consideration of race consciousness.
Explicitly.
And so, but it's what Justice Brown Jackson does, what I love, is build from that into our contemporary moment of how race matters. And she looks at every sort of meaningful condition of life, health, wealth, education, and traces racial gaps, and then traces them back.
And he says that that is meaningless in his
says it's
concurrence.
meaningless, and she's hooked on victimhood.
Yes.
Is what, and she says, "Oh, too many straw men to deal with." Thomas,
And he's also skeptical of this idea of systemic racism, thinking it's almost an insult to people like Thurgood Marshall.
Well, let me
you can
just
never achieve as a person of color if systemic racism.
Yes.
Point two
Yes.
about the scope of this ruling. I think the majority opinion is deeply confused on what race means. So this Freedmen Bureau's example, what does it, is that the same thing as race to identify freedmen? And then at the end of the opinion, the Chief Justice says, well, Harvard and UNC can't do what they're doing, but of course you can consider an applicant's race if the applicant themselves brings it up.
As overcoming, as a description of overcoming adversity.
Take it too seriously in their personal statement.
How is this different than what Harvard and UNC were doing before? Is the point Justice Sotomayor?
I'm gonna get Maura in here. Maura, you had something to say about
I'm
this.
sorry. I just want to point out something that's been pissing me off, and that Mario and Jessica also touched on is that the majority opinion and to a degree also Thomas's concurrence, they try and take the story of racial progress, that they always begin the story with Plessy and end it with Brown. And they try to take the moral authority of the Black struggle, but divest it of any kind of moral content, right? And Thomas does this all the time. He's like, it is a story of removing racial considerations from our law towards this ideal of what Roberts calls the colorblind Constitution. And that's completely ahistorical, which is one of the reasons I'm really glad to have Jackson on there, because what the court has sort of commanded that these schools do is abandon what is the best argument for affirmative action, which is to remediate historical injustice, right? They've said that you're not allowed to have a remedial argument that says, we are going to shape our classes this way because our past has been something dishonorable and we want to be an agent of change. And so, Jackson, I'm really grateful for her dissent because she kind of rehabilitates the rehabilitative argument, says, this is actually a historical trend of being very race conscious and being conscious of history and using the law affirmatively, as even President Johnson said, to try and undo that history.
Well, to the point that was made that now Justice Thomas cannot stand alone with with how he has articulated about the experiences of Black people, I think many will find to be refreshing. Let me just say that it also seems as with Justice Thomas, to the extent that race matters, it matters about his own life. If you think about the Dobbs decision, for example, when he says that all of these other areas of privacy, I'm happy to see the court deal with them and kick them down the curb, with the exception of interracial marriage. He and Ginny should not be affected. In the Bruin decision, just the day before that, so in Dobbs, you will not find any sort of record of there needing to be a prologue related to women. In fact, women aren't mentioned. You will not find in all of the Dobbs decision these two words, Black woman or Black women, at all in the entirety of the decision. But the day before in Bruin, Justice Thomas says a prologue is necessary. A prologue is necessary to understand the plight of Black men historically when they have not been able to own guns. And he spends 5 paragraphs talking about Black men whom I think that he might see some sort of likeness to. A Black man who is a music teacher, a Black man who is a professor in mathematics, that kind of thing. He's not afraid to go there in history and reflect about what might have been himself in history, but certainly not others.
All right, so this is an area where I think a lot of the news media coverage of it, you know, this case is seen as abolishing affirmative action, I think is overly simplistic. And I think it's notable, as the commentators pointed out, that prior case law wasn't directly overruled here. And that really all the Supreme Court seems to be saying is something similar, or an argument could be made, all it's saying is something similar to what it said before, which is you can't have racial specific quotas. But if someone outlines in their application how they have been disadvantaged by racial discrimination, how they've been impacted, and that should be considered in evaluating their application, you can still do that, as Chief Justice Roberts pointed out in the majority opinion. I also think this case is not going to end up being as eventful as a lot of people think it's going to be, because it's not an abolition of affirmative action. It can't change the fact that in order to understand and address inequality, you have to know what the inequality is in order to achieve equality. I thought it was interesting. I don't know if any of you saw it, but there was a discussion on, there was an answer in Jeopardy, I think it was, which talked about what had been the promise of reparations by the Freedmen's Bureau. And the question is, what is 40 acres and a mule? That's the commitment that had been made. It was never a promise, never kept, but that's the commitment that was made. And it was made to a group that is explicitly a racial group, the freed slaves that the Freedmen's Bureau was trying to help at that point in time. That would have been a form of affirmative action, and is close in time to what the framers of the 14th Amendment were thinking about when they framed that amendment. Do we have any questions on this area before we go to the next item?
Okay, the next case is Indian welfare. It's Hallen versus Brackeen upholding ICWA, which is Indian Children Welfare. And that was a 7-2 decision, and Arizona versus Navajo Nation regarding water rights, which was a 5-2. The first case upheld Native American.
Second case is 5-4, not 5-2. I don't think there were any recusals. And the first case 7-2, which is kind of interesting, which I would point out on the 7-2 case, is we should all know who those two are. And without even reading the case, without knowing anything more, just knowing the way this court behaves, we should all know that it's Alito and Thomas, I believe. The 5-4 decision was kind of interesting to narrow the rights of the Navajos regarding water rights. They had been made a promise in their treaty that they would get the amount of water reasonably necessary. And the answer was, well, Congress has a lot of power over treaties, including apparently the power to simply ignore the commitments it has made. So, and that's what the 5-4 outcome was. Let's go ahead and play that one.
So I want to get to the Indian child welfare case. So Jessica.
So this case, Holland versus Brackeen, involves a challenge to the constitutionality of the Indian Child Welfare Act, which was a statute passed by Congress in 1970 1978 to address a horrible situation, the widespread removal of Indian children from their families to non-Indian families. And what ICWA does is it sets up some procedural safeguards to get in the way of the removal of an Indian child. It gives tribes some voice in those adoption decisions, and it sets out a scheme of preferences for who can adopt Indian children with Indian families first. Now, this case was a challenge brought by a couple different sets of potential adoptive parents, including Chad and Jennifer Brackeen, who wanted to adopt another Indian child. A plaintiff was also a birth mother in the state of Texas. The Supreme Court surprised everyone by upholding ICWA by a vote of 7-2 in an opinion written by Amy Coney Barrett, who herself is an adoptive mother. The court said that the Constitution gives Congress the power to regulate Indian affairs in this way, gave Congress the power to pass ICWA. One interesting thing about this is that the majority kind of found that power not in any specific textual provision, which is unlike Dobbs, where they said, well, we don't find this right to abortion in any specific textual provision. But here, not having a specific textual hook doesn't matter. They said Congress does have the power to pass ICWA. And then importantly, they held that the plaintiffs didn't have standing to argue that ICWA was race discrimination, which is great because this case represented a threat to all of federal Indian law. The federal Indian law was characterized as race discrimination rather than protecting the political sovereignty of tribes. It would be disastrous. And so commentators were very excited by the result in this case.
I'll add the one other point for con law scholars is there was a point about something we call an anti-commandeering principle, right?
Right.
So, anti-commandeering is a sort of 10th Amendment principle that suggests the federal government cannot conscript states into a federal regulatory scheme. So, right, the federal government, if you want the states to do something, you have to incentivize them, you have to invite them as part. You're not allowed to pass a law that then requires the states through their mechanisms to essentially help you achieve the federal purpose. And the claim was ICWA did this to state adoption agencies. And the court had been in a series of cases, Prince, New York, Murphy, had been very hostile to the federal government statutes, which seemed to create any requirement. But here, it was interesting. They were sort of the mind that the requirements that were created for states through ICWA were ancillary, and that they governed states in the same way they would sort of govern private entities, which is from a case called Reno versus Condon, right? And so my sense was, but that's not what we've been seeing. So this was a bit of a surprise in their commitments to easing off on their pro-state sort of sovereignty 10th Amendment positions. Now, you will not be surprised that Justice Thomas wrote in dissent to hold up the very point you raised, which is there is no explicit Article 1 power that authorizes ICWA, so it should be deemed unconstitutional.
Okay. Okay. Do we have any specific questions on these two cases? I think they just stand for sort of the broad principle that the court is still upholding the right of Congress to regulate Indian tribes. That can be both for good and for bad, but the Congress has fairly broad power. Any questions here before we move on? Oh, and the liberals in the 5-4 case, it was, I don't remember. I think it was just one. I think it might have been Gorsuch joining the liberals on the 5-4 case, the Navajo case. That would be my bet, but I can't remember for sure. But just again, Gorsuch is more open on ruling in a way that's pro Native American. Next item.
Now I can unmute. For some reason, I'm sorry, it wouldn't let me unmute, but there was no questions, and the next two cases are very short for our audience. So we're
yeah, let's go through both of them.
Yeah, why don't we go through both of them?
Would any of you say that this is Justice Thomas's court now?
I know his clerks like to call him the real Chief Justice.
Yeah.
Ooh.
I'm just gonna go out on a limb and say, I would not say that. I would emphatically reject that idea.
Yeah, I would say, I would both reject it, but also say to the extent that the court operates without any real regard to any broader principle other than like the exercise of its own power, that strikes me as like very reminiscent of just like Thomas's whole deal.
But I can't say it's his court because he's most known for articulating over and over very narrow and extreme positions, right? He doesn't typically write in the majority.
It's an interesting thing. So when our daughter was about 9 years old, I took her to hear Supreme Court arguments.
Poor baby.
But the interesting thing, as we were sitting there, she leaned over and she asked me, she said, "Mommy, why does it look like the black judge, he looks asleep?" And he did look asleep. And I have to say that in these times, Justice Thomas is awake. He's not woke, but he is awake.
But he's not, he's barely more verbal.
Okay. Okay.
We were going to briefly comment here just on Justice Thomas and his role. And I guess what I would say is that I don't think it's the Thomas court. I think that Roberts is being very careful. Roberts gets to a point, whoever writes the opinion of the court, as long as Roberts is in the majority. If Roberts is not in the majority and Thomas is in the majority, then Thomas gets to decide who writes the opinion of the court because he's the most senior justice other than Roberts. And it seems to me that Roberts has been trying to make very sure that Thomas writes mostly dissents, and acerbic dissents from either side are rather useless in terms of achieving anything in the long run. I had shared with others in preparing for this presentation the notion that, over time, the conservative justices on the Supreme Court, not so much the liberals, but the conservatives tend to drift politically. And over time, they typically drift to the left. That would a lot of work ought to be done on the Supreme Court, because it's the one thing where you might make a difference, is trying to ignore and isolate people like Thomas and Alito, and trying to develop and reach across to the conservatives who are not authoritarians, and or to Gorsuch on Native American issues, and trying to see if you can build coalitions that get you better outcomes. So I think if you think of it the way it really is now, it's the Roberts court, but if someone could emerge from the liberal side, it could turn out that the conservatives are in a minority of 6, because you've got at least 2 or 3 conservatives who can be dealt with, negotiated with on a lot of important issues.
Did we go to the next case?
Yeah, we can just do the next one. And were we going to leave off Groff versus DeJoy? If we have time, we can still do it, but let's do Biden versus Nebraska next, the student loan case.
Again, 6-3, Department of Education v. Brown, Biden v. Nebraska. Who wants to quickly take that before we close out?
I'll give the quick facts. The quick facts was this was his attempt to use something called the HEROES Act of 2003, which allows the president and Department of Education to make, in times of emergency, certain modifications to student financial arrangements. And the real question was whether, first of all, there was standing to bring the case by states who brought it in Biden versus Nebraska. And the court found, with not a lot of meat on the bones, that there was an injury at least to Missouri. The second question was, did the secretary and the president have the power to cancel the debt? And the court found no, on a theory of basically statutory interpretation, which says that canceling debt, that $430 billion in debt, was neither a waiver nor a modification within the meaning of the language of the statute, because it was too transformative.
How do you reconcile the ruling today with the affirmative action ruling? I mean, it seems almost, can one say that this is a court that has abandoned any kind of knowledge of people deserving to be educated? what do you make? I mean, can you see any thread? Do you see any thread between the affirmative action case and the student debt loan?
I would say the court does it, right? Put one squarely in the bucket of presidential power, executive power, and the other within equal protection and sort of understandings of the limits of considerations of race.
The thread I perceive in the two cases is more that in each one it's the court taking a very outsized role in deciding what any sort of other actors in the society can do, right? In the case of the student loans, the court's saying, we don't like the vibe of this, so you can't do it. And with affirmative action, it's like, we also don't like the vibe of this. If you do it in this very particular way that we're not going to really, exactly articulate what it looks like, but if you do it that way, then we might be okay with it. But otherwise, we're not. And in both cases, it's not really any clear rule, any real clear thing that policymakers, elected officials can follow. It's just the court's discretion. And it's the court claiming large amounts of discretion for itself.
Yeah, I was reminded of Trump versus Hawaii, where they say the statute says what it says. The president has the discretion to make this determination in the interest of national security about, banning, sort of which visa. And here it's like, no, those words mean something very particular. And this is not waiver or modification.
It's a court that then is opportunistic, perhaps, in some of its rulings that we've seen in
Here, it's kind of interesting. This is kind of a very sort of cynical approach of the Supreme Court. On the one hand, saying, well, if the executive is allowed to forgive student loans, that's making a less accountable division of the government. The executive take control over the more politically accountable unit, the legislature. And of course, what they don't say is, so in order to resolve that conflict, we, the least accountable division, will come in and intervene, even though the language of the statute might seem otherwise rather clear. I don't know what to say about the decision. And again, it's another case where standing has been bent. It was really unclear that anyone had standing to bring this lawsuit, but standing doesn't really seem to be important, even though it's a constitutional requirement. We were going to also discuss Graf versus DeJoy. My thought is to just make that a very quick discussion right here, as opposed to playing the discussion of it. It's the only 9-0 case we were looking at among the cases this year. And what it basically held was that the United States Postal Service has to accommodate people who, for religious reasons, don't want to work on Sunday, I think it was, and that they have to make that accommodation unless they can show there's a severe hardship. The standard used to be quite a bit lower than severe hardship. So this case really is overruling, at least arguably is overruling prior authority. But their prior authority, you might argue, was rather weak in protecting religious freedom. And I think there was a widespread agreement on that, and it was a 9-0 decision on which there was a great deal of consensus. I think that finishes all the specific cases we were looking at. Not, in some respects, not as interesting a year. It could have been a lot more interesting if we had lost the very first case we discussed. If that had come out the other way, it would have made things very interesting, because it would have become clear that we really no longer live in a functioning democracy. So that's how things are running from year to year. We have to wonder what the outcome is going to be on that issue. Let's open it up now for questions. So we'll see what we've
That's
got
right. We
in chat.
can stop sharing, Rich.
And Tom, weren't you going to talk about the two concepts about religious freedom trumping?
Yeah, there's and I guess I would say first about the concept of religious freedom conflicting with civil rights is, the more I think about it, I think the cases that we saw, the 360 Creative, in the end, the case was decided on such a narrow set of facts. I don't think it really poses a threat to civil rights yet. I mean, it could be a harbinger of things to come, but is this Supreme Court really going to say that someone can say, well, my religion is against, for example, interracial marriage, and I don't want to serve dinner to Justice Thomas or anyone else who's part of such a marriage because it causes me to have to violate my religious prerogatives. On the other hand, I think we'll still respect people's religious freedom to the extent of, if you're a restaurant and you decide that you're a Jewish deli, for example, and you don't serve pork and bacon, and you don't serve pork and bacon to anybody, so you're not discriminating against them, you can exercise your religious freedom. You're not required to make a bacon cheeseburger just because someone wants one. So I think despite the tenor of some of the language and the way the press has been interpreting the case law that's been evolving, I think in the end, people who are going to say, well, I'm not going to rent a hotel room to a gay couple, I'm not going to serve them in my restaurant, things like that, are going to be acting at their own peril. They're still in violation of the law if the legislature of that state decides and the authorities in that state decide to enforce it. I was also going to just briefly revisit the abortion issue because it's going to, I think, harbinger of things to come. It's going to continue to be an issue. Everyone, I think, has assumed that when Dobbs overturned Roe versus Wade, it was just putting the issue of abortion back in the hands of the states. This Supreme Court could well decide at some point that a fertilized egg is a human being entitled to rights of life, liberty, pursuit of happiness under the 14th Amendment. And if that's what the majority of the Supreme Court decides, abortion would become illegal and unconstitutional everywhere. Now, I'm not saying that's going to happen, but when you listen to some of the extremists on the political spectrum and what their solution is to abortion, their solution is a nationwide ban. Even though they talked about the idea of states' rights, that was just a fig leaf to cover up what the real effort is going to be here. So there you go. Those are two issues I guess I would say are possible things to look out for as we go forward.
Tom, one question that had come in from Mayron had to do with what you were talking about before, but he wanted to know, why do you think the conservatives are drifting to the left over time? And is it,
that's been the case for decades now, ever since I was in law school. It's something we observed back then. I don't know. I don't think anyone's even tried to study why it is. They've studied that what is in fact happening, but they haven't studied why. And of course, it's not something that's universal. I don't foresee Alito or Thomas drifting to the left, but I do think already we've seen some drift to the left by Roberts. I mean, he proved to be the key vote on some important issues. Notably, I think it was Obamacare. So, I just don't know the answer to that question of why. If we knew why, we could replicate it, hopefully, but that's not happening as quickly as I would like to see.
anybody else have questions? I think that's it. Unless you or Carol have more comments.
I don't, I'm wondering if Connie wanted to say anything.
I just want to say great job, Tom.
Oh, well, thank you.
I learned so much from you today, and you add so much. If we just played that video without your commentary, we would really lose out. You do a great job. Thank you.
Well, thank you. I try to sort of, I bring it to what I'm thinking of it as, which is perhaps a little simpler than the commentators are thinking, but the Supreme Court shouldn't be, the decisions it makes shouldn't be so complicated that we're all left guessing at what they mean and that there's some sort of mysterious thing. The law is not a mysterious thing. It's something we should all be able to understand. And if we don't all understand it, it's because the lawyers and the judges aren't explaining it well enough. So it's our fault if the regular layperson doesn't understand. So I appreciate the opportunity to sort of present things and answer questions. It's a really good opportunity.
So just and I agree, we all agree with Connie, you are the best, and we learned from you. But one of the things that is facing or has been commented on is, do we push for term limits? Do we push for more judges? So I know you have opinions about that.
Yeah, there are all sorts of, I'm glad you raised that question, because there are all sorts of things. And I guess I would say it's not worth charging at windmills. It's not worth it because it's just a waste of time and energy. We can't impeach anyone because we don't have, and we have no way of getting in the foreseeable future, a 2/3 majority in the Senate to impeach people. And if we pack the court, we run the risk of tit for tat. We add 3 members, the other side gets control. They add 5 members, we add, 7 more. And the Supreme Court pretty soon becomes a legislature. I mean, as it is, 9 people is hard to think of as a court or a board of directors or something like that. It's already beginning to look like a legislature, and it's already overly politicized. So I don't think that's the good path either. I think if we could define why some justices drift to the left over time, we could focus our attention on being more persuasive and trying to help more justices shift to the left over time. And ways we can do that are by not exaggerating the breadth of decisions that have been made so that people don't feel that they have to defend those decisions in the future. We can just say, oh yeah, you voted in favor of that, but this is a completely different case. And we should be focused on that. I also don't think we should try to, which we could do, but I think it's fraught with danger, is take away most of the jurisdiction of the Supreme Court. The only mandatory jurisdiction it has are those things that are within what's called its original jurisdiction, which is only basically disputes with foreign governments, disputes between states, and a small handful of other things. And so you could take away the Supreme Court, but that would be chaotic to the legal system, because then you'd have all sorts of different results state by state and no way of ever reconciling any of them. So there's no easy answer to what we've got with the Supreme Court. I guess I would say that the progressive and more liberal elements in this country, the Democrats, have been far less attentive to the judicial branch than they should have been. And what you ought to consider doing is creating, there's an analogy to the Federalist Society. It's called the American Constitutional Society. It's nowhere near as strong. It's nowhere near as pervasive. It doesn't develop candidates for judicial branch appointments. It should be reinvigorated. So we should be thoroughly exploring how we can be more persuasive, spend less time writing acerbic dissents, and more time thinking about who the appointees are going to be on a forward-going basis, and making sure that our appointees to appellate courts in particular are people who are able to persuade and push for compromise, as opposed to people who write eloquent dissents. This may be a harsh thing to say, and it's probably not true in the long run, because sometimes dissents end up being very valuable half a century or a century later. But in my view, there really is no such thing as an excellent dissent. A dissent ends up most of the time, on most cases, in the trash heap of history. And you're better off writing a majority opinion. And if you can't write the opinion of the court, you're better off writing a concurrence. And how you get there, I don't know. I certainly wouldn't have been writing concurrences myself on many of these decisions. But that's the goal. The goal is you want to write as many opinions of the court as you can, be in the majority, and be in the majority on the right side of the issues. And that's a tough goal to achieve.
So that other society that you mentioned, I think, forgot what you call it,
American Constitutional Society.
Right. What do they do? If they don't develop candidates or put forward candidates, what the heck are they doing?
They hold programs, they advocate for their point of view, but they're not as aggressive or as well known or as public as the Federalist Society. I mean, you've heard of the Federalist Society, you know who they are. And the fact that none of us really know what the American Constitutional Society is doing, headed by, who's the former senator from Wisconsin?
Feingold?
Yes, it's headed by him, or he's one of the lead people in it, Feingold. And I'm sure it's a good organization. I'm paying them dues money because I want there to be something analogous to the Federalist Society, but there really isn't anything with the power, the strength, the depth, the monetary support of the Federalist Society on our side of the fence. And there needs to be. And how that gets done and who does it, I don't know. But it needs to be done, because people get very unhappy with the things the courts do. And you tell them, You know, certainly I think a lot of people were saying in the election of 2016, this is going to be a very important election in terms of what the Supreme Court's going to look like for the next half century. And people's attitude when you would tell them that was just kind of, yeah, well, I don't like Hillary. And my response to that is, politics isn't not about just who you like, but about the issues and about the qualifications of the person and about what the person will do when she is in a position of power. And when you think about how much different this court would have been if the 3 appointments made by Donald Trump had been made by Hillary Clinton, can you imagine? We would be having so much different of a discussion. We'd all be wearing party hats and blowing kazoos. And the other side would be the one having this sort of gloom and doom discussion that we have to talk about our reality of having only 3 members on the court. So elections matter, votes matter, who is in a position to make appointments to the courts matter, and they matter a lot. And on our side of the fence, we just didn't get a good outcome. And we didn't get a good outcome because I think in part, I'll say this, the nation was, for whatever reason, not ready in 2016, or at least not as ready as it should have been to get the electoral college votes it needed, not ready to elect a woman president. And we see the massive destructive impact of that on our judicial branch. And we see it in what the Supreme Court does.
Yeah. Well, thank you.
Sorry to say it so glumly, but that's just the way it comes across.
On a more positive note,
yes,
Biden has been able to get a whole lot of appointments into the judiciary. That's obviously been a focus of his administration, and they've been doing it with pretty good alacrity. So that should help balance things, I hope.
Agreed.
All right. Well, thank you so much.
My pleasure.
That brings us to the end of our program today.